All right, let's talk about what needs to be done once you have received notice from the Secretary of State that your articles of incorporation have been filed. What needs to be done once you have been actually incorporated. We're going to talk about organization activities. We're going to talk about the Shareholders Agreement. We'll talk about the annual report of your corporation and other filings you may need to make with the Secretary of State. We'll talk about what a foreign corporation is and how you file those forms. We'll talk about when your corporation might be doing a business under an assumed name. And then we'll talk about ending the life of your corporation through dissolution. All right, let's talk about post-incorporation organizational activities. So these organizational activities can either be done by the incorporator or the board of directors. Remember what an incorporator is. An incorporator is someone who simply submits the articles of incorporation to the Secretary of State for filing, and in those articles of incorporation, in that submission to the Secretary of State, you will list this person or these persons as the incorporator. Once again, you, the lawyer, might be the incorporator. Or you can have the board of directors complete these organizational activities. The board of directors, where do they come from? Well, in your articles of incorporation that you file with the Secretary of State, your initial articles of incorporation, you can put in those articles of incorporation the initial board of directors. So it would generally include your client and other people who your client designates, or other people your client is setting this corporation up with. Or the incorporator can appoint the directors. So the initial directors either come from the initial articles of incorporation, which will list the initial directors, or the incorporator can appoint the initial board of directors. What types of things do they need to do? Well, you need to draft bylaws, and we'll talk more about bylaws in a subsequent chapter. We've already mentioned bylaws, but these are generally the rules that govern the internal affairs of the corporation. How do we handle meetings? How many directors do we have on the board of directors? How do we elect them? That sort of thing. We also need to appoint officers. Corporations generally require 3 officers. It depends on your jurisdiction, but normally you have to have 3 executive officers: the president, the secretary, and the treasurer. More on that in a subsequent chapter. The board of directors or the corporation at this time should adopt any shareholders agreement that the shareholders have entered into before incorporation or during the incorporation process. We'll talk about that in detail in the next slide. And finally, we need to raise capital, so we need to issue stock. We'll give stock to these investors in exchange for some sort of capital contribution. Let's talk about what needs to be done with the shareholders agreement once your business has been incorporated. First, let's talk about what is in the shareholders agreement. So if you are representing a client and your client is setting up a corporation, you should strongly advise that person to have a shareholders agreement with the other people who will be shareholders in the corporation. The shareholders agreement will deal with some very important issues. It will deal with pre-incorporation issues. What do we need to do to get this corporation up and going? It will deal with subscription. A subscription is just a promise to invest in the corporation, a promise to buy shares from the corporation in exchange for some sort of capital contribution. And so you can imagine, as several promoters, several potential shareholders are getting together and they're discussing setting up a business and setting up a corporation, we want to lay out what each party will bring to the table. What capital contribution will they make to the corporation in exchange for stock in the corporation? In the shareholders agreement, we might want to talk about how we're going to govern this corporation, who's going to be a director, who's going to be one of the executive officers. Talk about business issues, right? Not just the internal governance, but the business issue. What business will we be doing? We might want to put that in the shareholders agreement. And finally, a very important part of the shareholders agreement is what we call a buy-sell agreement. A buy-sell agreement is simply where the shareholders discuss what will happen if one party wants to buy the other party's shares or one party wants to sell her shares to one of the other current shareholders or maybe an outside investor. Now, at this point, once your business entity has been incorporated, the corporation should adopt the shareholders agreement. Typically, the shareholders sign the shareholders agreement before the business has been incorporated. Once the business has been incorporated, now we have a legal person, the business, the corporation, and that legal person should sign the shareholders agreement. Now, of course, the corporation is not a shareholder in itself, but there are certain provisions in the shareholders agreement that requires the cooperation of the business entity. So we need the corporation to sign the shareholders agreement. Once the corporation signs the shareholders agreement, it is bound by the provisions of the shareholders agreement. As we go through the semester, as we go through this course, we'll talk about certain provisions of the shareholders agreement and how it affects the corporation and how we might need the corporation to cooperate in the enforcement of these provisions. All right, let's talk about the annual report and other filings you may need to make with the Secretary of State once your business has been incorporated. So the annual report is very simple. Don't think of the annual report as the annual report you will see from a public company. That is a securities regulation issue. Securities regulations, federal securities regulations provide detailed information that a public company must disclose to its shareholders in its annual report. This is not what we're talking about. The annual report that a corporation must file with the Secretary of State just will state the current directors, officers, and the registered agent of the corporation. So it's quite a simple filing. Most jurisdictions require it to be done every year. There are some jurisdictions that don't require it anymore, but most jurisdictions still require the corporation to file an annual report with the Secretary of State. There might be other filings that you need to make periodically with the Secretary of State. For example, if you change your registered agent, do you remember what the registered agent is? The registered agent is the person who is authorized to receive process on behalf of the company. So if you're going to change your registered agent, you have to submit a change form to the Secretary of State. If you're going to amend your articles of incorporation, we've talked about this, but if you're going to amend your articles of incorporation, you have to send a form to the Secretary of State. And it's usually called the Articles of Amendment. Here's a quick look at the Articles of Amendment form that you can find on the Kentucky Secretary of State website. You will notice in items 2 and 3 that is the space where you actually write your amendment. It's not a lot of space, it's kind of limited, so you would probably draft out your own articles of amendment and you would not use this form. But naturally you would refer to this form to help you draft your own articles of amendment. This is what most law firms do. And if you are changing your registered agent, that might happen, then this is the form that you would use. Once your business entity has been incorporated in one jurisdiction, it might have to register as a foreign corporation in another jurisdiction. So what do we mean by a foreign corporation? Well, simply it's any corporation that's not incorporated in a particular jurisdiction. So for example, if your corporation is a New York corporation, it's incorporated in New York, as far as California is concerned, that is a foreign corporation. If you have an Ohio corporation, as far as Kentucky is concerned, that is a foreign corporation. So if you are going to transact business in another state, if your corporation incorporated in a particular jurisdiction is going to transact business in another state, you have to register as a foreign corporation in that state. Once again, it's a simple form that you have to file, but you have to register. Now the question is, what do we mean by transacting business? Right? And the definition isn't necessarily always clear, it's kind of vague, but here are some basic guidelines. So if you are just soliciting orders from the other state, you do not need to register as a foreign corporation in that state. You're not transacting business in the state. You're transacting business in your state of incorporation, and you're just receiving orders from the other state. If you are sending goods to the other state, you do not need to register as a foreign corporation in that state. Once again, you are doing business in your state of incorporation, and you are just sending goods to the other state. If you are going to set up an office in the other state, or if you're going to regularly perform services in the other state, then you need to register as a foreign corporation in that state. Okay, I just wanted to give you a quick look at the form you would use to register as a foreign business entity in Kentucky. Other states will have similar forms. Let's talk about doing business under an assumed name. This is actually very common. Many corporations do business under an assumed name. Remember, we talked about the difference between a corporate name and the brand. And sometimes the corporate name will be different from the brand. And you'll be doing business under the name of the brand in many cases. So here's an illustration. Let's say we incorporate a business and the name we incorporate under is Alpha Beta Foods, Inc., right? But we set up a food truck under the corporation, right? The corporation runs a food truck called Paulie's Pizza Truck. Now the corporation is doing business under an assumed name, Paulie's Pizza Truck. Now you might ask, well, why do we have to file this certificate of doing business under an assumed name? Well, the idea is that if someone does business with Paulie's Pizza Truck and now needs to sue Paulie's Pizza Truck, there is no Paulie's Pizza Truck to sue. Paulie's Pizza Truck is not a legal person. The legal person is Alpha Beta Foods, Inc. And so the people who do business with Paulie's Pizza Truck need to be able to find out somehow who is actually behind this business. Who do I sue if I have some sort of complaint or dispute with Paulie's Pizza Truck? This is very common. Imagine I, as a sole proprietor, right? I don't set up a business organization. I'm a sole proprietor, and I set up a bar called Bourbon A Go-Go, right? And someone comes into my bar, and someone has a dispute with Bourbon A Go-Go. Well, there is no Bourbon A Go-Go. There's only me, Chris. So I, as a sole proprietor, would have to file this doing business under an assumed name, the certificate, with the Secretary of State. Let's look at the form. Here's a quick look at the form you would use in Kentucky if you are either a domestic, a Kentucky business, or a foreign business entity doing business in Kentucky under an assumed name. Let's discuss dissolution of your corporation, the euthanasia of legal persons, dissolution. All right, so your corporation is a legal person. Its existence required a state filing. Ending its existence also requires a state filing, right? This is called dissolution, and the filing is normally called articles of dissolution. This is an important issue. Your clients might forget about this. So they might set up a corporation, and for whatever reason, the business doesn't get off the ground, or the business comes to a screeching halt, and they just stop using the corporation. Well, they really should take steps to dissolve the corporation. Now, let's contrast this with liquidation. These are very related concepts, but dissolution and liquidation are actually a little bit different. So dissolution is the ending of the legal existence of the corporation. Liquidation is what follows upon that. Well, once you dissolve, then you have to liquidate the assets of the corporation, sell the assets, and meet the debts of the corporation. You have to satisfy the debts of the corporation. So dissolution is ending the legal existence. Liquidation is actually the process of selling off the assets of the corporation and paying off the creditors. Whatever is left over, that goes to the shareholders. That's the residual. And this is the form that you would use if you were dissolving your corporation in Kentucky.